think whilst we're just waiting for those people to join, I'll just give you a little bit of information about the event today. So as I said, we're delighted to have John, Victoria and Marco from Marsh JLT Specialty with us today. Marsh have been and JLT Specialty have been a supporter of Bristol Law Society now for three or so years, and we enjoy a very supportive relationship with them, and they've done a number of events with us in the past. So some of you may have been to those, and I'm sure that some of you here on the call will know them individually and working with them in some form in any event. But you know, they are a broker, they're a leader in the insurance broking and risk management, and of course today they're here to talk to us and give us an update on the market, which Marco is going to lead on in just a moment's time, and then Victoria Prescott, who is the Senior Vice President, will focus on supervision whilst working from home. I know that's something that a lot of lawyers are struggling with, whether you're the one that's being supervised or the one that is doing the supervision, but you know, that's certainly presented some challenges for lawyers, and so she's going to be providing analysis of notifications during lockdown. And then after that, we're going to welcome John Pennie, also Senior Vice President, who's going to be discussing after the event insurance and kind of giving us an update on that, and you know, where you need to sort of look for the dangers in terms of preventing a professional negligence claim. So I think we'll get cracking if that's okay. So Marco, if I can hand over to you, and I'm going to say we are recording this session. The slides will come to you after the event, and the recording shortly thereafter once it's just been edited. We're going to put the questions and answers at the end of the session, and so do feel free to use the chat box or the Q&A function, and we will pick those up then. But in the meantime, yeah, please do put your questions in there, and I'll hand over to Marco now. Thanks very much indeed.
Thank you, Helen, and thank you everybody for joining us today. My name is Marco Davidio, and I focus primarily on helping solicitors here in Bristol and in the Southwest with professional indemnity and, in fact, all insurances, all risk requirements they may have. As Helen said, I want to take a few minutes before I hand over to Victoria to sort of talk through the market conditions and the issues we're seeing and what we're keeping an eye on. So I think if we go to the second slide, please, Victoria. So the first thing to talk about is the open letter published by the IUA last September. The IUA is the International Underwriting Association, and they represent insurers who work in the London market but sit outside of Lloyd's. So that includes nearly all of the world's largest insurance companies. They were expressing concern through this open letter that under solicitors' professional indemnity insurance, insurers can't cancel policies and have to provide 6 years run-off cover even if the premiums aren't paid. Although this didn't change after the letter was sent, it may have been a factor in what we saw in October 2020. As well as price increases, there were changes in how insurers behave. They didn't all take the same approach. So for some, that meant reducing their limits of indemnity, or they increased excesses, and sometimes they were looking for the support of a co-insurer. Right, just bear with me a second, sorry. There were occasions when these excesses were uncapped, and you'll see from the figures on the slide that some of these excesses were really substantial for the bulk of the firms that we represent. Some insurers required personal guarantees from equity partners, particularly for limited companies or LLP firms, and it remains to be seen if that will continue into 2021. Looking ahead, we need to watch out for cyber insurance exclusions. Again, this is something that's infecting insurers across the industry and could result in changes to the minimum terms and conditions. But at the minute, discussions with the SRA are ongoing between insurers and the SRA. Can you move to the next slide, please, Victoria? So how can you prepare for your next renewal? In the current market, the broker you pick can make a real difference to the renewal outcome. One of the things we saw after October was firms coming to us for help. And when we looked at their renewal submissions, there simply hadn't been enough detail to provide insurers with comfort. In some cases, we were able to retrospectively help them and get a better response from insurers. This isn't easy, so it's better to iron out any questions before negotiations start. Insurers this year will be looking at supervision, financials, cybersecurity, and training, as well as your contingency plans. So make sure you showcase what your firm is doing in these areas. Insurer meetings can be helpful, but most solicitors will be reliant on the renewal submission to show what their firm is all about. So spend the time to get that right. Make sure that every question on the proposed form is answered and include details of large or unusual losses, the steps you've taken to prevent reoccurrence, and any positive factors. I would also recommend it's best to summarise information rather than supply copies of policies or procedures. If you move to the next slide, please. We have a large dedicated team both in London and within the regions, and we all work closely together to make sure our clients get the support they need. A lot of the work is generally at renewal, but throughout the year, our claims advocates are on standby to help whenever required. Our risk management team provide bulletins, training, and a wealth of thought leadership materials. A lot of these are on topical matters, such as the supervision talk we'll be moving on to in a minute. We place a significant amount of business directly with insurers, so we have a chance to speak with them and understand what their concerns are. The benefit to you is that we can share this information and help you identify and address these areas. We audit all submissions before they're sent to insurers, and it's with all with the aim of ironing out as many potential questions as we can. The objective behind all of this is to maximise insurer interest in a satisfactory renewal outcome. The bottom line is it does take time, so start early and let us know if we can be any help. We'll be happy to provide a copy of these slides at the end, and if you require them, please email me. My contact details will be provided by Bristol Law Society if you don't already have them. Thank you for listening, and now I'm pleased to hand over to Victoria, who's going to continue to talk on supervision.
Thanks, Marco. I'll just start showing my slides as well, and thank you for you all coming today. Hopefully you can all see those in big screen now. So we're going to talk about risk in the current environment today. Areas of discussion we're going to cover. We'll be looking at practice area and risks, and we're going to focus on a comparison of notifications between 2019 and 2020. And then we're going to look at some claim predictions that we think might happen in the future. Then the main bulk of today's presentation will be in relation to supervision, and we'll touch on the current regulations, supervision and workload, remote supervision and change, and then we'll look at collaborative review as well as a potential mitigant. So first of all, the comparison that we completed. So this was from 2019 and 2020, and we looked at the dates 24th of March to the 3rd of August. The reason that we picked this period was because the first lockdown started on the 24th of March, and we knew for until the 3rd of August that full measures were in place, or significant measures that limited normal working practices. So what we wanted to see is whether notifications to insurers changed during that time. We looked at 28 law firms, we looked at large and mid-sized firms, and this means top 100 UK firms or firms with 11 plus partners. We identified 150 notifications in total, and we're able to clearly code 112 of those notifications, which meant we were able to identify the practice area, the work type in that practice area, and actually what had gone wrong as well. We were able to see in 2020 that there was a slight increase in notifications to the same period in 2019. When we looked at practice area, we were able to identify that there had been an increase in private client work, private client practice areas during 2020. And that was not a surprise to us because we knew that this practice group was particularly busy during the first lockdown. Additionally, we saw rises in commercial real estate and also small rises in corporate and commercial work. We saw notable decreases in 2020 in dispute resolution practice areas and also residential property. And again, residential property wasn't a surprise to us because we thought lockdown happened and almost overnight the market went into a stop. However, When we looked at actually the work type being completed in the practice area, we were able to identify that residential conveyancing remained static in the 2019 and 2020 period. And actually the change in the reduction in residential property related to actually litigation work that was being completed in that department relating to residential disputes. So that's where the drop came in 2020. We actually saw significant jumps in sale and purchase work that was being completed, and also wills and trusts, which focused back onto the private client work. We saw also significant drops in litigation work, which linked back to the dispute resolution, practice groups, and also residential property, as just mentioned. When we looked at error type and what actually was being notified, it was interesting that we saw that drafting errors during this time were notified higher in 2020, as well as mistakes as to advice and tax errors. What decreases happened were communication breaches, potential data breaches, and service errors. And that was quite reassuring, because we'd all been sort of on warning that actually working at home might lead to more confidentiality breaches or data breaches, and this wasn't what we saw during the first lockdown at all. Additionally, we saw that lawyers were very, very good at keeping in contact and communicating with their clients. There was a static between 2019 and 2020 concerning time limits, and this was because we saw drops in time limit errors in areas such as litigation work, but actually increasing in time limit error notifications concerning private client work that was being completed, as well as corporate and commercial work. So what do we anticipate for the future? Well, claim predictions, where we think these are likely to happen, is where a claim is yet to crystallise, or it's still possible due to the ongoing restrictions that are in place, and potentially new restrictions in the future. First area we think could be a problem is residential property department, and specifically conveyancing work being completed. And this is due to two reasons. One, either being an inadequate COVID-19 clause being used by the firm, and this is the clause which protects against delays to completion due to COVID-19 without default, or alternatively, where a COVID-19 clause is not appropriate, potentially because the other side won't accept one, where the client has not been advised about potentially simultaneous exchange and completion, and then something goes wrong linked to COVID. Additionally, we have concentrated on private client potential risks concerning wills. The issues here being potentially wills that are incorrectly witnessed, not executed in time, full advice not being provided normally due to the urgency of the situation and more assets being discovered later, and undue influence arguments. Unfortunately, we've already seen all four of these potential risks starting to show in some of the notifications or inquiries that we've received. So moving on to supervision, as I said, this is going to be the main bulk of the presentation today, and it's impossible to talk about supervision without touching on the regulations. There have been important changes to the codes at the end of 2019, and there were direct and indirect changes impacting supervision requirements for firms. In relation to direct changes, we saw the strengthening of the SRA's obligations for supervision for firms and solicitors, owing to firms now having to have an effective system for supervising client matters, and for solicitors effectively supervising work that was being done for them. Additionally, a new accountability section was added to the codes, which brought to the forefront a quasi-vicarious liability provision for firms and supervisors, again relating to the work done by others. This prominence for supervision veers away from the traditional potential soft approach that could be said that the SRA have taken. We have previously spoken to individuals who were at the SRA when the codes were being drafted, and it was an intention by the regulator to focus on supervision going forward with law firms. Concerning indirect changes, there are new recording provisions within the Code of Conduct. For firms, this is very, very clear at 2.2, where you need to keep and maintain records to demonstrate your compliance and obligations with the regulatory requirements. And that directly can be linked to demonstrating you have an effective system for supervising work. Additionally, for individuals, there is now a requirement that you can be able to justify your decisions and actions going forward. And as we know, as lawyers, if it's not written down, it didn't happen. And therefore, indirectly, there needs to be records of what supervision you are taking. We recommend that all records of supervision are kept, including any ad hoc meetings that you have with your fee earners. The codes are intentionally flexible to allow you to decide what you want to do yourself, but unfortunately, as said, if you don't have adequate records and any sort of allegations are made in the future, it will be very hard to rebut allegations that you disagree with. The SRA are planning to release in the very near future more guidance on supervision for law firms, and we are hoping that they will touch on the recording provisions for supervisors at this time. If they do, and when this comes out, we are planning to release a bulletin for our lawyers to understand the implications. The SRA have produced their own COVID approach sort of guidance during this time, and they've highlighted that they still expect solicitors to continue to meet the high standards that the public expect. They will be pragmatic and proportionate in their approach, and they will sort of accept that we're in exceptional circumstances. However, they have highlighted that they will still refer to the enforcement strategy as normal to look at serious misconduct and distinguish between people who are trying to do the right thing and those who are not. During that COVID approach, they have actually highlighted also their own contingency plans, which the SRA says includes home working to ensure that they keep and maintain their service for the public. And so maybe on a more cynical approach, it could be suggested that the SRA will have less sympathy for firms who didn't have a sort of a good contingency plan for home working before the pandemic, or have not promptly updated their plan since we went into the first lockdown. The SRA have confirmed via Juliet Oliver, who's the GC at the SRA, that they do expect more effort is required as time goes on. So I think it's not going to be possible to really sit on not adequately supervising people if policies weren't in place to deal with home working before the pandemic going forward. So we have seen this new tough approach, or this new intended tough approach by the SRA concerning supervision, and it started to be reflected already in some of the decisions that we're seeing. In this first decision I've highlighted, it's important to note that Mr. Morgan was looked at under the old codes of conduct, but when the new codes of conduct were in force, meaning that the SRA's tougher approach is being demonstrated here, even with the old codes. In this matter, Mr. Morgan was the supervisor for the law firm's bookkeeper, and during a period of 1 year, there were a number of unreconciled items on the book that Mr. Morgan failed to investigate or look into. It transpired when Mr. Morgan did investigate the issue that there was some £24,500 that had gone missing, and in fact the bookkeeper had stolen the money. Mr. Morgan promptly notified the matter to the SRA and put right the money that had been taken immediately. He was looked at and investigated under the accountancy breaches, but also under failing to adequately supervise. And as we know, that's now changed to effective supervision. In this agreed outcome, it was found that he accepted those allegations and he was fined £2,000. So it does demonstrate this change of attitude by the regulator to supervision. And this is one in a spate of cases that we've seen since March that are starting to be more highly publicised. When looking at supervision, it's absolutely necessary to consider workload. Being an effective supervisor includes ensuring fee earners have the necessary capacity to do the job. Marsh, in conjunction with Legal Business, conducted a survey of large law firms in 2020. And one of the questions that we asked the law firms was, what did they think was causing problems and potential claims within firms? 10% of the firms said that they thought it was due to a lack of supervision within the firm, and 26% of firms said this was due to potentially pressure of workload and pressure of deadlines. Now, although there's a separation in the study, it's clear that effective supervision is absolutely necessary to ensure that workloads are properly managed and resulting claims avoided. And so the two issues really do interlink, and pressure of deadlines and pressure of workload really is linked to a supervision error as well. An example of workloads not being adequately managed and potential frightening results can be demonstrated in this anonymous case study. This was a firm within the top 50 and involved a number of junior fee earners who were working at that firm who had substantial workloads and couldn't cope. During their time at the firm, they had minimal supervision and minimal checks to ensure that they were able to cope with what they were dealing with. They couldn't cope and unfortunately started telling clients that cases were progressing when they were not. In some cases, certain fee earners actually confirmed settlements had been reached with the other side. And when it came to paying settlement monies to their clients, they actually paid the money from their own bank accounts rather than admit that they'd fallen behind in their caseload. So this is a really good example of how people can lose perspective, especially junior fee earners, when workload creates too much pressure. But also it's a very prime example of a substantial breakdown in supervision with disastrous consequences. We're also seeing wellbeing and supervision increasingly being mentioned in regulatory reports and claims. In the case of Matthew Sparrow, a Clyde & Co employee, Mr. Sparrow was investigated for a breach of Principle 6 and not a dishonesty issue. And he'd produced an inaccurate attendance note reflecting that an agreement had been reached to extend time limits with the other side. In fact, it had not, and the matter went to the Solicitor's Disciplinary Tribunal. It was accepted that he'd produced a misleading note and that had breached Principle 6 of the Code of Conduct. But what was really interesting with this case was the mitigation that his QC used. At that time, the QC placed a great deal of emphasis on the significant pressure that Mr. Sparrow had been whilst he was employed by Clyde & Co. Additionally, the heavy caseload that he'd been given from the job start and the fact that he'd requested reduced workload during that time, but had in fact been given more work to do. Now, we're not saying that the mitigation that was used by Mr. Sparrow's counsel is accepted by Clyde & Co. But this is one example of where very detailed supervision records would be very helpful to both Clyde & Co. or both a firm and a supervisor in a similar situation. Additionally, this is a situation where we're looking at 2018, an SDT matter under the old codes, where now we have these strengthened obligations and this vicarious liability provision, where we think it's much more likely that the regulator would ask more questions of the supervisor who was involved with Mr. Sparrow, and also the firm as to their policy of supervision. So moving on to remote supervision and change and home working in general. So we see a number of increased risks owing to home working, and we've just noted a few of these down here. We've got the increased risk of cybercrime and supervision that we've touched on, and we're going to discuss in a little bit more detail. Additionally, we have personal issues that could affect people due to home working, and training and development problems. Finally, it's important to note notification behaviour might also change during this period. We are moving into a recessionary climate and people are concerned about job security. It's situations like this where people are much more likely to maybe try and deal with mistakes that happen themselves, as opposed to where they might have before been a bit more courageous to actually tell someone when something's gone wrong. So it's clearly an issue that we need to keep in mind. But supervision and what supervision was before has clearly changed. Previously, we had this office traditional approach, which was a one-to-one situation, either ad hoc in the office or by formal meeting arranged in the office. But whilst being in the office, we also had the opportunity to see if someone was looking a little bit stressed and maybe pull them aside and make sure everything was okay. The difference now that we see is this home and flexible environment where supervision meetings are more announced either via Zoom or Teams or telephone, and people are expecting to talk about supervision in a much more sort of announced manner. However, we do have this increased opportunity for broader input due to the circumstances that we have now, and that's something that we're going to focus on a little bit more concerning collaborative review. So collaborative review as a mitigant, what is it? Well, it is a group review of any work output, which is already used in a number of industries, including, for example, the NHS or in the airline industry. It's a meeting of 3 or more people where you sit and discuss the approach to a case. It's a type of show and tell, really, where you have a sort of 5 or 10 minute slot to discuss what you're dealing with, the issues you're seeing, and your planned approach. It can also be a piece of drafting that you've done or an opinion that you're intending to produce, where again you give a short lowdown of what's going on and provide that piece of work. On the back of that, the attendees that are at the session provide input. What we understand is that this sort of collaborative review already exists in most firms. Marsh conducted a survey in 2020 at the tail end, and we were able to identify that 60% of people who responded highlighted it was already being used in their firm in some way. Now, we don't suggest that collaborative review is sensible for each and every case, but potentially as part of a difficult piece of work or a high value complex matter, this is work which could have a great deal of benefit to the individuals dealing with the matter. It's also a valuable learning experience for the whole team. And it really helps with that sort of training and expansion of knowledge, where we're not having those water cooler moments anymore. So building a case for change, why now? Well, it really does dovetail with a remote working culture, and it's very low effort. We're working in an isolated environment, and it gives us the ability to really discuss issues and problems that might be occurring. It's already successful in risk improvement. It's been tested, it's been proven, so we can come along and pick up really sort of all the hard work that people have done before to know that this does work. If you've ever had a difficult situation or a difficult problem at hospital, it's very possible that you might have been mentioned to you that your consultant's going to take the file to a group meeting. Well, this is the collaborative review meeting where all consultants sit down and discuss a difficult patient's case. So we know it does work, and we know that it's important in reducing risk and potential issues. It aligns with best practice across the firm. And is a good demonstration of risk improvement, both to underwriters and to the regulator. And so it aligns with that sort of stakeholder corporate approach where it can be demonstrated that you're looking at the current situation and changing and adapting to ensure that learning development and errors are reduced adequately. And it prevents that silo working environment that most underwriters are quite fearful of. It's important to note, or interesting to note, that the SRA actually use collaborative review themselves. They've highlighted that when they have a tricky ethics question, they have a group meeting where they all sit down and discuss all the potential outcomes and thoughts of what they think could or should not be done. So again, it will align with what the SRA think is a good way of training and development and ensuring problems don't happen. Just finally, touching back on that original slide we looked at regarding what issues that we see happening with potential increased work and increased risk and remote working. Collaborative review actually can affect most of those issues and actually be a mitigant to all those potential problems in some way. So as you said, for supervision, it really does help with the supervision and ability to tackle tricky problems that you might be facing. It also is the overview of the supervisor to make sure people are on the right track. But for training and development, it really is a really helpful one for people to gain and expand their knowledge through different cases that are discussed. From a personal perspective, it can also reduce people feeling so alone. They're going to be having more group meetings and seeing people more, and that actually might link and affect notification behavior as well. So when people are more in a group sort of environment, either via Zoom or via Teams experience, then they might really allay some of their fears as to job security and potentially being worried about not notifying problems going forward. So some mitigants there for other areas as well as supervision. I'm going to be answering any questions at the end of the presentation, but I'm now going to pass over to John Pennie to talk to you about litigation funding. Over to you, John.
Thank you, Victoria. Hello, everybody. Can we look at the first proposition slide? Right, just reading that quickly. It's all to do with the failure to explore with your clients whether there's funding for litigation, and if there is, whether you could buy adverse costs insurance. Clearly, what people don't say very loudly often enough is that in all litigation, in all adversarial litigation, there's a 50% failure rate. When you think about it, in court every day, somebody's won, somebody's lost, and they're both there because their lawyers have decided that it was a good case and a case worth pursuing. So against that background, let's have a look at the next slide. Because what we need to do as boring lawyers, frankly, is to have a look and see what the regulations say. And as Victoria just said, these were tightened up in the July of 2019. And what's quite clear now is that in paragraphs 8.6 and 8.7 of the relevant code of conduct, it's vitally important that your client, if you're engaging in a contentious matter, must know all about the likely overall cost of the matter, all the options available, and what costs are going to be incurred. So if we have a look at the next slide, we'll see that, as I just said, losing a trial, and there's a 50% failure rate, as we just heard, that has a direct impact on the likely overall cost of the matter, to use that wording. Therefore, looking at this in the context of, well, what can I do about that risk, the risk of losing, is incredibly important. Next slide, please, Victoria. So what every firm has to have is an engagement letter. In all contentious matters, the engagement letter essentially deals with, or should deal with, exploring the availability of funding for the litigation and adverse costs cover. What we've seen in notifications, and what is an emerging pattern, is that these engagement letters are not always read and understood by the very people sending them out. And worse, quite a lot of engagement letters say things that are never followed up. And so there is, frankly, a problem with a lid on it at the moment, but waiting to blow, where it could be said that if you've got an engagement letter, if it has all the right wording in, but nevertheless, you haven't explored whether or not adverse cost insurance is available and funding for it is available, something has gone badly wrong. And what people forget too is that the adverse cost insurance premium can be paid at the end. It doesn't necessarily have to be paid up front. And there are even policies where you only pay if you win. But that's for another day. Let's look at the next slide, please. Because this is the frightening bit. In 2010, so a case that's been around for over 10 years but not widely enough known about it, the court held that it was a gross breach of duty for the solicitor in the case not to advise the client on the availability of adverse cost insurance, of ATE. The analysis said that if a solicitor doesn't do that, then bearing in mind what we saw in the Code of Conduct, the solicitor is effectively acting without instructions, because the clients weren't able to give anything like full instructions because they didn't have an informed view of the case. Commentators have said that ad risk should be better known, and that essentially, as you'll see from the next slide, it produces some pretty obvious consequences. So let's have a look at that next slide, please. What it really boils down to is that if you're not looking at funding options, if you're not then looking at the availability of adverse cost insurance, then potentially there could be a negligence claim against you by your very upset client when you tell him that he's got to pay the other side's costs as well as yours. Down from that, there could be regulatory criticism, which is always embarrassing, and indeed professional embarrassment features big time there. So frankly, it seems to me that it's a bit of a no-brainer to be resolving that there ought to be a really good look for every contentious matter at the availability of insurance. If there's a 50% failure rate, you wouldn't get on a plane unless you got really good cover for the flight. So 50% failure rate in litigation, it ought to have alarm bells ringing all over the place. Next slide, please. And here's the other thing that we've seen. There are people who think they've fulfilled their obligation and have dodged any risk of negligence by just going back to the outfit that supplied them with the adverse cost cover the previous time. That's generally thought not to be good enough. There needs to be market testing, and that is quite a burden for a busy lawyer, because have you really got the time, and who's going to pay you to be phoning around 5, 6, 7, 8 providers? It takes ages. Whereas a broker does that for free. And it seems to all us brokers, but we would say this, wouldn't we, that there's a tremendous benefit in delegating that shopping around to us. It then fulfills the important need for you to be seen to have been getting it right and delivering what you said you're going to do in your engagement letter. So let's move to the second proposition, please, Victoria. Next slide. And this is something of a confessional, having been 30 years as a litigation and insolvency lawyer before joining Marsh. There are lawyers out there whose training took place at a time when everybody was rather sniffy about funding. Words like champity and maintenance were being bandied around, and it was all seen as a bit grubby. It still is in some jurisdictions, Australia and Ireland, to name just two of them. In the UK, however, the judges at the very highest level have given a very large and smiling judicial thumbs up to the concept of funding, and indeed the concept of insuring against the risk of an adverse cost order. So if we look at the next slide, please. here's one way of looking at it. You can get adverse costs, and you can cover, and you can get funding if you've made sure that the barrister, usually a QC, but not always, helping with the case, has given the case at least a 60% chance of success. Now, I know percentages are irritating, especially to lawyers, but what that really means is a good or very good chance of success. If you've got that, then you can move to the next square and explore through your broker getting funding, and more importantly, even if you're going to fund it yourself or back end load the premium, getting in place an adverse costs policy. Next slide, please. And just consider what would happen if you'd lost. The recriminations would go something like this, which is there was at least a 60% chance of success, which is why you brought the case in the first place. For whatever reason, you didn't explore getting adverse costs. That then means that you've probably let your client down rather badly. And what can you say to that client? Because it's no good saying, oh, well, we wouldn't have been able to get it. Because if you're saying to a client, we wouldn't have been able to get the adverse cost cover, then he will say, well, why on earth did we bring the case in the first place? And you need a very good file note to prove that he was a headstrong client that you duly warned. So it seems that if you haven't thought about and documented the proper discussion about the availability of adverse cost cover, then sadly, you may be in a very embarrassing situation. Final slide, please. So the option is to test the market, and you've guessed it, one way of doing that, of course, is to use a broker. So with that ringing in our ears, can I say thank you very much for your attention. If there are questions, now is the time for them. Thank you very much. Back to you, Victoria, and the Law Society.
Thank you very much, John. I think we're just welcoming back our panel. I think at the moment, hopefully, please do get your questions and answers in there. We'll give you a few minutes. Actually, I've got one question or comment, I suppose, directed to Victoria on her presentation regarding supervision. I noted that there's been some discussion in the Law Society Gazette and with the junior lawyers in particular, I think, being concerned about investigations against them and the issue, I suppose, that relates to cover, largely covering sort of partners and compliance officers, but junior lawyers not being covered so much in cases. I just wondered what your view of that as a broker is. I understand that the junior lawyers are undertaking a survey, I think with Lee Day at the moment, about this particular issue, because I think they're feeling that obviously they're not as well funded, and sometimes the cases against them, they've been unrepresented. I'm
just reading the comments as well at the same time to just to understand the background to that. So bear with me for 1 second. Yeah, I see. So from a broking perspective, I can't answer that. I'm not a broker. I'm a barrister by trade, so I'm a lawyer. So Marco, if you've got any comments on the broking side, in relation to having cost protection from sort of professional indemnity insurance, there are very particular rules that relate to when funding can be sort of applied for, depending on your actual professional indemnity policy as to investigations. So from that point of view, I can't comment. From a sort of a supervision side, we've seen previous cases like the MW matters where there were particular issues with supervision, and arguably junior fee earners being held out to dry, but not from the fact of a supervision issue, but from what the dishonesty allegations that were made against them. I think on the back of that, I think the changes in the supervision requirements actually are going to give the SRA a really good stick to hit law firms with in the future, where the focus won't be on junior fee earners going forward. I'm not sure if that really answers your question, but Marco, is there anything you would add there?
Sorry, I had some connection problems, as you know. Can you just repeat the question, Helen? What you were
yeah, I'm aware that junior lawyers are at the moment the junior lawyer division of the Law Society, along with Lead Air, conducting a survey into sort of defence insurance on the basis that I think they feel that a lot of junior lawyers feel that they, when there's an SDT investigation, that they are, as Victoria said, perhaps more the low-hanging fruit, and just interested in your view of that, and to what extent, that, as Victoria said, actually some of the cases have been around dishonesty, perhaps not around supervision specifically, but again, I was just interested in to what extent insurance might cover some of the more junior members.
Yeah. I suppose it would largely depend on the circumstance. I mean, if it was a failure to, obviously from the legal services point of view, where they felt a client and they were brought up to task by the SDT, I'd like to think that as part of the claim the client might bring would obviously include their defence as well. If it's in the cases that a lot of widely been reported, ideally more like management liability, directors and officers cover would probably be more appropriate, as it was in the Lead A case. It was primarily directors and officers cover that provided them legal defence against the Ministry of Defence. So yeah, perhaps directors and officers might be waived or PI, but it would really depend on each circumstance as to where it would lie.
Thank you. I can't see any questions and answers. You must have done a great presentation, everybody.
We have got, if anybody's interested on collaborative review in any more sort of depth, we have published the results of our collaborative review survey from 2020, which if anybody emails you and wants a copy of that, then we can send that out. It's not widely available, so it's sort of given away on a case-by-case basis, but if it's requested, we're happy to share that with attendees today.
Right, we'll definitely put a note of that in the email that is going to follow up to everybody. So look, I'm just going to give you just a couple more minutes. Anything else that anybody wants to ask? Whilst we're just waiting just to check that there aren't any last minute questions, anything else that any of you would like to add?
No, just thank you for coming today. Very difficult circumstance, especially. I think everybody's still got children at home and home working, so that's one of the downsides of home working, apart from the flexibility. But hopefully things will get a bit smoother next week for everyone.
Absolutely, yes. I think that's going to make a big difference for a lot of people, isn't it? So fingers crossed that first step out into the roadmap, that key stage, brings the rewards of the next steps for us all. But look, I think that it looks as though we've answered any questions in the presentation that people may have. So just finally to say thank you very much to our panel, John, Victoria and Marco. Thank you very much for your time today. To our delegates, thank you very much for giving up your lunch hour. We will get the slides to you. There will be a recording of this to come out in the next few days as well, so we'll get that to you. And as Victoria said, if you do want access to their collaborative review report, then just drop us a line in response to our email that will be coming out to you, and we can put you in touch with Marsh. But failing that, I hope everybody's keeping well and have a good rest of the day. Thank you very much.
Bye-bye.